Good morning. My name is Suzanne Badawi. I'm an attorney at Sheppard Mullin, and I'm on the Committee of Professional Responsibility Insurance for the California Bar. I'm here today to do a presentation with respect to clients threatening to sue and legal malpractice claims. So what I'd like to do is I'd like to give you some tips about what the best practices are if you do get a malpractice claim. And that's what I'm going to talk to you about for the next 10 minutes. Generally, statistics demonstrate that lawyers can expect one malpractice claim for every 7 years of practice. That might seem like a lot, but really the question is, do malpractice claims actually translate to legal malpractice lawsuits? So what I'd like to talk to you about is if you do get a claim for malpractice by one of your clients, what should you do? What are the best practices in terms of how to deal with that claim? So what I'd like to do is I'd like to start talking to you about the things that you should not do, because I think that's the best place to start. And then I'm going to talk to you about the things that you should do, and then I'm just going to talk to you about some mitigation tips. So let's start with the things that you should not do. Don't assume that a claim means a lawsuit. Contrary to public perception, the filing and prosecution of a legal malpractice lawsuit is not easy. But making a claim is very easy. There's a lot of things that clients have to consider if they're going to convert a malpractice claim into a lawsuit. Data confirms that most legal malpractice claims are meritless. And sometimes clients threaten a claim in order to avoid paying a bill or just because they're not happy with the outcome of a case or the outcome of something that's happened. That doesn't mean that the lawyer has done something wrong. Moreover, even when claims involve actual mistakes that the lawyer has made, it doesn't mean that just because a mistake was made that that was malpractice. Lawyers can make mistakes that don't necessarily mean the lawyer has committed malpractice. In California, in order for a mistake to be able to convert to malpractice, the mistake must proximately cause damage. Also, clients who sue their attorneys waive the attorney-client privilege. That's another consideration that the client has to make when they convert a malpractice claim into a lawsuit. And there is the time that the client has to spend in litigating a malpractice lawsuit that the client's going to have to think about before they file a lawsuit. Also, when the client decides to convert a malpractice claim into a lawsuit, they're going to have to hire a lawyer, and their lawyer is going to sit with them and tell them whether it's worth it, whether the benefit of suing and the cost of suing is actually worth it to pursue. These are all factors that may result in the malpractice claim not converting into a lawsuit. So don't assume just because there's a claim that that converts into a lawsuit. Another really important don't is don't admit legal malpractice. You have a duty as the attorney to keep your clients informed, including self-reporting when mistakes happen. However, there's a fine line between the duty to report material facts that are material to the representation of the client and admitting legal malpractice. And if you admit legal malpractice, that would virtually assure that a legal malpractice lawsuit will follow. Attorneys who fail to timely report mistakes to their clients face significant consequences. For example, the statute of limitations can toll because the client has a certain amount of time within which they have to sue the lawyer for malpractice, but that time can be tolled if they don't know that their lawyer has made a mistake. So concealing a mistake can create problems for you down the road. Also, there can be bar grievances, there can be a conflict of interest. Failure to report to the client that something has happened increases the likelihood that the malpractice claim will convert to a malpractice lawsuit. Indeed, one of the factors that most motivates plaintiffs' legal malpractice attorneys to file lawsuits is the concealment of a mistake, because juries don't react to that very well when they know the lawyer has hidden a mistake from the client. Just remember, not all mistakes equal legal malpractice. So you want to let the client know something happened, you want to report as you're supposed to, but you don't want to admit that you committed malpractice. Let me tell you about some consequences if you do make that admission. Such an admission can make defending you down the road in a malpractice claim difficult for a lawyer. Also, an admission can constitute a violation of the no admission clause in your typical legal malpractice insurance policy. So you want to be careful not to admit it. So I would say the best approach to follow is what I call the Joe Friday rule, just the facts. You tell your client something happened, you give them the facts, but you don't say, hey, I committed malpractice, because that's a legal conclusion and hasn't been determined yet. Another thing that you want to consider also when you're reporting the facts to your client is maybe get the opinion of another lawyer before you tell your client what happened, because really typically attorneys are the worst second guessers of themselves. And it's really helpful to get the objective opinion of a third person in terms of whether you did something wrong and how to go ahead and let the client know what's happened. Another don't that I want to tell you about is don't ignore the problem. This strategy rarely works. If a client is convinced that the attorney has committed legal malpractice or done something wrong, they're not going to let it go. So you don't want to ignore it because it's going to materialize. The best thing is to deal with it. So what do you want to do? Engage with the client. Turn over your file. Respond to the client's inquiries. Engage with the client, because these are all things that might help to diffuse the problem. And the other thing I want to tell you not to do, this is another don't, is don't sue the client to get ahead. A lot of attorneys think that this is an opportunity to get ahead of the curve by filing their lawsuit before the client sues them for malpractice. And usually the attorney will file a lawsuit for attorney's fees that haven't been paid. This makes the likelihood of a legal malpractice lawsuit very likely, because it's very likely that the client will respond to your lawsuit for fees with a lawsuit for malpractice. Now, there are some situations where you do want to file a lawsuit to get your fees, or you do need to get ahead of the curve and file the lawsuit first, but those situations are rare. I'd say the best practice, unless there's some overarching interest to file a lawsuit, is to not file the lawsuit first, just to get ahead of the curve. Another don't I want to tell you about is don't make settlement offers without the insurer's consent. Now, you may be tempted because there might be an opportunity to get rid of this quickly for a small amount of money, and you might feel like you want to just settle it and get it over with. But the problem with that is that typical malpractice insurance policies prohibit an attorney from making a settlement offer without the insurance company's consent. So it's critically important that you coordinate with the insurance company. The risks of failing to do so are significant. Settlement offers without the insurance company's consent can jeopardize the coverage for the entire claim, even if the settlement that you're proposing is within your law practice's deductible. So attempts to settle without involving the insurance company are just too risky, and I would say do not do that. So those are the don'ts. That's what we just covered. Best practices when you get a legal malpractice claim. What shouldn't you do? We went through that. Let's now talk about what you should do. What should you do? Well, when we talk about what you should do, you need to think about your insurance policy. You should have a legal malpractice policy in effect, and what you should do is you should look at that policy, you should know what that policy says, and you should know what your obligations are under that policy when you do get a claim. So the things you want to think about is typically in a legal malpractice insurance policy, there is the duty to report malpractice claims. So you need to distinguish between an actual claim and a potential claim. Those are two very different things, and the reporting obligations are potentially different. So what is an actual claim? An actual claim is an actual demand for money or services. Virtually all legal malpractice insurance policies require immediate written notice of an actual claim made during the policy period. So if there's an actual claim made by your client, report it immediately to your insurance company. But a potential claim is a little bit trickier. These occur when the attorney becomes aware of a fact or circumstances that might give rise to a claim, but the client has not yet made a claim. This can happen any time a client suffers an adverse ruling or a transaction falls apart. In those situations, attorneys have to think about, is this something that I need to report to my insurance company or not? Now, it's a fine line to walk, because if you're reporting to your insurance company every time that an adverse situation arises in litigation, that could affect your insurability, because you've got all these claims reported against your insurance policy, and that might affect your insurability down the road. So you really want to think about, is this something that is this situation a situation where I have made a mistake and my mistake has resulted in an adverse situation for my client that could hurt my client? Those are the considerations that you want to make when you're looking at whether a potential claim is something that you want to report to the insurance company, or should report. And you can always get advice, if you're not sure, from a lawyer who specializes in that area. Also, the worst time to consider whether your policy is the right policy for you is when a claim has been made. You always want to be looking at your malpractice policy and making sure that it provides the coverages that you're going to need when a claim does arise. And that's something you want to do typically before you renew and when you initially get your insurance policy. Don't wait until a claim comes in before you look at your policy. Because if you do that, there may be exclusions, you might not have enough coverage, you might not have everything that you need in that policy to take care of the situation. So it's something you want to look at before a claim comes in. So these are the do's and don'ts. Generally, there's more, and this isn't everything, but these are the main considerations that I would consider when you do get a malpractice claim. Thank you very much.